Lifting the corporate veil. What is corporate veil? After an incorporation of a company, the company itself and the members in it are treated as separate legal entity, and there is a veil that divides the company and its members. When does lifting the corporate veil takes place? The court will break through the corporate veil by applying the principle of lifting the corporate veil happen when there's any fraudulent and dishonest use is made of the legal entity. The members who committed the wrong liable will not be allowed to take shelter behind the company, and they will be personally liable for those debts and obligations. Lifting the corporate veil principle can be applied when there's a statutory exceptions and judicial exceptions. Under judicial, there were 6 exceptions. The first is fraud or improper purpose. Second is avoidance of contractual obligations. Third is group of companies. Fourth is public policy. Fifth is company employed as an agent or alter ego of its controller. And the last will be protection of revenue. In statutory exceptions, the first will be misrepresentation in prospectus. Second is solvency statement. Third is payment of dividend. And the fourth will be signing of instruments.
The first exception is fraud or improper purpose. The case example will be law always will not assist fraud. So if a company have been used as a mask for a fraudulent action, the court may lift the corporate veil and make the members liable for the action made. An example case will be for the situation is Rebulge Press Limited 1960. In Rebulge Press, there will 3 shareholders, that's Jackson, Shaw and Threlby. Jack and Shaw is major shareholder and Threlby is minority shareholder. Jackson and Shaw wanted to get rid of Threlby, the minority buying his shares, but Threlby rejected the offer. Jackson and Shaw incorporated a new company where the company offered to buy all the shares in Rebulge Press. Jackson and Shaw accepted the deal, but Threlby declined it. So the angry Jackson and Shaw shoot Threlby so they could acquire Threlby shares. So the court found that there is sufficient grounds to refuse the acquire to squeeze out the affected remaining minority shareholder. So it lifted the veil. Jackson and Shaw Holdings Limited and held the company as harm. The court may lift the corporate veil if public policy demands it. There were a case Daimler Co. v. Continental Tire and Rubber Co. 1916 where the company has become an enemy company even though it's been incorporated in England, but the identity of shareholders turns the company into enemy company because the shares were held by Germans. This happened during WWI when the English government issued no business could be conducted with enemy, namely the Germans. An example case will be for a company was incorporated to avoid a legal obligation is John V. Lipman.
The third exception will be avoidance of contractual obligations. It happens when a company was incorporated just to avoid a legal obligations. The example case can be used is Johns vs. Lipman.
following that company employed as an agent or alter ego of its controller. Subsidiaries are frequently found to be the agent of the parent company. After ego theory can be applied when parent company being dominated towards subsidiary. Next exploitation is group of companies. Sometimes in the case of group enterprises, the Salomon principle may not be adhered to and the court may lift the veil in order to look at the economic realities of the group itself. Example of case Hotel Jayapuri Berhad versus Hostel Bar and Restaurant Worker 1980. The last exception will be protection of revenue. A company was incorporated for escaping from tax paying intention for protect the profit earned. Re Sir Dinshaw McNigy Petit will be the perfect case to describe.
The first statutory exceptions will be misrepresentation in prospectus. Prospectus is a statement which delivered by company having share capital to the registrar for registration at least 3 days before its first allotment of shares under conditions of where company does not issue prospectus, company issued prospectus but does not have proceed to allow any of its shares. Second exception is solvency statement. A solvency statement is a statement in writing signed by all of the directors which states as regards the company's situations at the date of the statement. The solvency statement in the lieu of the court's confirmation is required for the reduction of the capital unless the reduction is solely by way of cancellation of any paid up share capital which is unrepresented by available assets.
In payment of dividend. Under the Companies Act 2016, the rules on dividend have been tightened. Under Section 131, a company may only make payment to the shareholders out of profits of the company available if the company is solvent. However, in Section 133, subsection 2, liability of the director who willfully pay payment of any cash dividend in contravention of the dividend rules will be liable not to the company's creditors but to the company itself. Payment of dividend not of the company's profit or without willfully the solvency test is found in section 133 subsection 2. In signing of instrument, a company executes its documents by affixing its common seal subject in the constitution and signature in accordance with section 66 execution of documents. With subsection 2, a document signed shall have the same effect as if the document is executed under the common seal of the